Good afternoon, everyone. My name is Pranami Sharma. I'm the assistant professor at University School of Law and Research, USTM. Today, we will be discussing one important topic in the entire legal profession, that is all about Civil Procedure Code. So, Civil Procedure Code eventually one of the very toughest subject and one of the very important subject in this professional course. So, here we will be discussing basically about suits under this CPC, which was enacted in the year 1908. So, before coming to the point, let me give you the overall view of the term suits. So, whenever we talk about suits, it all refers to civil suits, because whenever we talk about suits, there are two parties involved. One party who is filing the case, that is considered as plaintiff, and the another party who is defending that case based on the document, that is considered as defendant. So, in case of civil proceedings, in case of civil suits, we are concerned with these two parties. Whereas in case of criminal proceedings, we are concerned with petitioner and the respondent, that is basically referred in case of CRPC, which is renamed at present as Bharatiya Suraksha Sanhita. Bharatiya Nagarik Suraksha Sanhita, which brought some new changes in the year 2023. However, here we will be focusing in case of filing a civil suit in the civil forum. So, before filing a civil suit, there must be, as obvious, a cause of action required. That means the party, whoever is filing the case, that party must have some specific reason behind this. Once this reason is specific, once this reason is decided, that means that party is suffering from some loss, and based on that, the jurisdiction will be noticed. Once the jurisdiction is being specified, after that, the party, with the help of the jurisdiction, with the help of his pleader, will approach to the court of law, and accordingly, the suit will be initiated. The first step in case of filing a civil suit in the civil forum is presentation of plaint. As I have said, this is the plaintiff, so that plaintiff will give his own evidence based on the document considered as plaint. So, similarly, some orders have also been mentioned in the Civil Procedure Code, starting from Order 1 till Order 51. All the orders are very important and required throughout these steps, from presentation of plaint till the execution of decrees. So, initially, the place of jurisdiction will be decided, the plaintiff will file the plaint, and the proceeding will start. In between, what happens if the plaint is not consisting of proper information, that might be rejected also. Let's see this rejection of plaint with the help of this specific points. As I have said, this is the pleading of the plaintiff. So, that might be rejected based on the following reasons, like where plaint doesn't disclose the cause of action, in case of bar of res judicata, relief claimed is undervalued, etc. As obvious, wherever and whoever is filing this plaint, that person has not mentioned clearly about the cause of action. The relief, whatever he is asking, is undervalued, it's not mentioned. So, in those cases, the plaint will be rejected by the court of law. Accordingly, conversely, that means if the plaints is being continued by the court of law, that means if the plaint is being presented by the plaintiff via the pleader in the court of law, in case of the civil suit, in that case, the next step comes into existence. In case of next step, we have to refer to Order 5, wherever the intimation should be sent to the defendant. That means the party, whoever, has to defend himself based on some documents, because in Indian law system, both the parties have to follow the system as per the Constitution of India, which is specifically talking about and which even giving some guidelines to the court of law that they have to maintain the natural justice. Both the sides must be heard. Based on that, the defendant has to submit his document, which is also considered as written statement, and the process via which this intimation has been sent to the defendant is considered as summons. So section 27 to 29 of the Civil Procedure Code is dealing with summons to the defendant. Contents of summons are likewise, suppose date of hearing, whether he alone will arrive or his pleader, production of witnesses, etc. This will be considered as the contents of summons. Once the summon has been given, now the modes has also to be considered. There are various modes of sending summon. As obvious, there are altogether 5 modes of summons are given in the Civil Procedure Code. Firstly, it is personal or direct summon, service by court, service by plaintiff, substituted service, wherever the summon can be sent via newspapers and all, and service via post, which can be directly sent to the defendant's residence. Then in case of written statement, the specific time limit has been mentioned by the civil code in the Civil Procedure Code, that is 30 days. Within 30 days from the date of summons, the defendant can file a written statement, but it can be extended up to 90 days. That means 90 days is the maximum period within which this defendant is supposed to give his document, that is written statement, which all particulars which will support his evidence. And this specific written statement is mentioned under Order 8 of Civil Procedure Code. So moving forward, we can also understand while discussing about written statement, the topic like set-off. Set-off can be maintained in case of recovery of money, and it must be a certain sum of money. There are 2 kinds of set-off. One is legal and another is equitable set-off, which is basically given in case of the uncertain sum of money, and it must be of same transaction. Here basically the order as well as rule is very important to be followed by the defendant. Moving forward to the next step, in case of suits under the Civil Procedure Code, that is all about Order 9, as well as the topic is appearance and non-appearance of parties. Now, supposingly, the situation is that the party plaintiff has filed a case with the help of the plaintiff, but on the day of hearing, that means first hearing, the plaintiff himself is absent. Then in that case, this whole suit will be dismissed, as the party whoever had filed the case, that party himself is absent. Otherwise, there might be some situations wherever the plaintiff is present but the defendant is absent. Plaintiff is present but the defendant is absent. In those cases, generally the ex parte decision has to be pronounced. But in between, the limitation period also comes into existence depending on the situation of the defendant. If the defendant has given prior notice based on the specific reasons, then in that case, it can be extended dependent based on the court of law. But suppose both the parties on the day of hearing, first hearing, are found to be absent, then in that case, obviously the case will be dismissed. So this whole concept has been based on 4 points. First is appearance of parties, non-appearance of either parties, appearance of the plaintiff only, and appearance of the defendant. Moving forward, we can understand this with the help of the production of documents. Now, in case of presence of both the parties, suppose both the parties are present, and the suit has to be instituted. Then in that case, once the defendant has arrived with full documents, which the written statement, in that case it is a duty of the court of law to verify the documents with the help of the affidavits submitted by the parties via the pleaders. Once this procedure is over, after that examination of parties has to be done, and while doing this examination, the court of law, with the help of the basically the pleader, checks whether any misconception has been given, whether it can be resolved via mediation, via negotiation. Based on that, we had one very important section, that is section 89 of the Civil Procedure Code, which itself talks about arbitration, mediation and conciliation. This type of matters includes generally the matrimonial affairs, wherever the dissolution of marriage is to some extent considered as one of the topic, wherever outside court settlements are done, wherever both the parties, both the spouses, if they are filing a divorce petition, in those cases generally the court of law, they think of doing some counseling under section 89 of the CPC, and cooling period has to be offered based on that via some mediator as well as conciliator. Then if it has not been solved via this procedure, then they can proceed with further inspection and production of documents. After that, gradually admission by either parties has to be done. Then based on all the observations, the issues have to be formed. Again, these issues are mentioned in order 14 of the Civil Procedure Code. Issues are of generally three types: issues of fact, issues of law, mixed issues of fact and law. So based on that, the entire law system is taking decision. Once this framing of issues are done, after that, depending on the matter, the court of law can ask for the witnesses. Now same procedure has to be followed. Summons must be given to the witnesses. Now here lies one very important concept while sending the summons to the witnesses, which also covers the evidence law, including examination of the witnesses. This whole examination of the witnesses as per the evidence law, which is for the time being known as Bharatiya Sakshya Adhiniyam, is based on three steps: examination in chief, cross-examination and re-examination. Case to case it varies. Then the next step, once this examination of witnesses are done, is all about judgment and preparation of decree, which itself based on proper evidence, which itself based on the evidence given by both the parties, as it has been mentioned in the Constitution of India itself under Article 22, that both that means both the parties, even the offenders or the accused parties, should be heard. So once this part is over, after that the next stage is of pronouncement of judgment. Once the judgment is pronounced, after maintaining the natural justice as in the Indian courts, the the judgment copy has to be derived within 15 days of pronouncement of judgment. Now there is one very important topic mentioned in case of Civil Procedure Code apart from judgment, which is totally absent in case of criminal law, that is all about decree. Once the judgment is pronounced, it takes hardly 15 to 20 days and the court of law prepares the decrees. And decree is nothing but the gist of the judgment. Initially, the preliminary decree will be given, and based on that, if the party, whoever is filing case, if that party is not getting the relief out of the decree pronounced by the judgment based on the decision given by the court of law, then in that case they have the provisions of filing appeal. These provisions of filing appeal are in the form of first appeal and second appeal. So in those processes they can move forward to the higher court, either in the form of High Court, and finally it is the Supreme Court under Order 45 of the Civil Procedure Code. So once this appeal provisions are given in the higher court, based on preliminary decree, they can wait for the judgment again, and once the judgment is given, after that also if the party is not at all satisfied, they can move forward to the second appeal and they can lie to the Supreme Court. So after this also it is not at all been satisfied, then in that case review procedures can be done. But there is a exception while doing review proceedings in case of civil procedure code, because in case of civil procedure code, review processes are done based on arithmetical or clerical errors. So that has to be looked after by the court of law. After this review process is done, then the whole decision has to be pronounced with full details given to both the parties. During this process, whatever judgment has been pronounced, if one party wins the case, that specific party will be considered as decree holder, and the party against whom the decree has been pronounced, that party will be considered as judgment debtor. Decree holder is the person who has derived all the benefits out of the decree given by the court of law. So during this, if the decree holder, they needs more relief, they needs more benefits out of it, and they are still not satisfied after this, there is one more procedure, that is all about execution of decrees. Execution of decrees consisting of 21 order as well as 106 rules in the Civil Procedure Code, one of the lengthiest order in the entire Civil Procedure Code. Wherever garnishee order has been mentioned, wherever it has simplified the concept of precepts and judgment debtor. So these are the basic informations related to the filing of suit in the Civil Procedure Code, which itself creates a important decision in the civil forum, which to some extent differentiate the matters related to Criminal Procedure Code, because in case of Criminal Procedure Code and in case of Civil Procedure Code, ultimately both the laws are having procedural norms. In both the code, either criminal procedure or civil procedure, the ultimate aim is to provide relief to the aggrieved party. So this is in brief about the suits under the Civil Procedure Code. Thank you so much.